The defence of excuse is different from that of justification. In excuse, the individual made a bad choice, but certain factors affected his decision. Duress, insanity, diminished capacity, intoxication, mistake of fact and mistake of law are all valid excuses that can result in a not guilty verdict or in a reduced grading of the crime and a reduced sentence. Involuntary intoxication results in an acquittal when the defendant is unable to form the mens rea required for the crime. However, involuntary intoxication is highly uncommon. The law is somewhat unsettled now for voluntary intoxication. An intoxicated person is historically held to the same standard as one who is sober. However, intoxication can obviously affect the mens rea. Intent to commit the crime can be inferred from the intent to get drunk in many courts. Under the MPC, the negligent drunk is deemed reckless. The fact that he wasn't aware of the dangers is deemed a result of his voluntary intoxication. Some lawyers claim that intoxication rendered their clients temporarily insane. Laws against being an alcoholic were struck down by the Supreme Court. Criminal law punishes acts, not the status of the individual. There's little social purpose in punishing the incompetent, so insanity is a defence against a criminal charge. However, the insane can be incarcerated regardless of their criminal culpability. Firstly, the defendant must be competent to stand trial. If they're able to stand trial with warning to the opposing counsel, then they can enter a plea of not guilty by reason of insanity. If this is accepted, then the individual can be held until they are no longer a danger to themselves or to society. It's becoming increasingly common for courts to deliver verdicts of guilty but mentally ill. The individual is guilty and receives the same sentence, but time is served in hospital rather than in jail. The burden of proof in an insanity defence is placed on the defendant. The tests used by courts to determine insanity have evolved over the years. The Macnaughton test looked into whether the individual knew right from wrong. This reserved insanity defences for only the seriously insane. The control test looked into whether the act was the result of a sudden and explosive fit. The broadest test of insanity is probably the product test. The court determines whether the crime was a product of the individual's insanity. The MPC test is now widely adopted. The test questions whether, as a result of mental illness, the individual lacked the capacity to appreciate the criminality, wrongfulness, of his actions, and was unable to conform to the law. It's significant that the word appreciate is more broad than knowing, and that wrongfulness is a subjective rather than objective standard. Was the act wrong in the eyes of the defendant himself? A mistake of fact can act as a defence if it negates the defendant's mens rea. Taking goods in the belief that they were abandoned is not theft. However, the mistake must qualify as reasonable under the common law. Ignorance of the law is generally no defence, however. But there are exceptions, when the law is not published or made available to the public. A mistake of law is a defence, if the mistake is made by the state and is acted upon in reasonable reliance by the defendant. In mistake defences, the burden of proof rests with the defendant and is decided by a preponderance of the evidence.